Might I straight away pick up your lordship's point that I was scrambling to answer for lack of refreshments, to be frank, and deal with it in this way. Your lordship asked about the effect of the June email, and it was really, I think as your lordship was trying to put it, the husband was given a stark choice, either that he sought legal advice or disclosure. In fact, he chose disclosure over legal advice, but that disclosure was not full and frank. And that is really a response to your lordship's question. And so the wife, we say, made a positive decision not to disclose, whether for tax reasons or otherwise. Might I also pick up on your lordship's point before I move on to the mediation point, which was the punitive cost point that I said that I'd come back to. There are two authorities, my lord. I'm not going to take them to you, but I can give you the references. One is WC and HC, at page 423, paragraph 64, and 418 at 14.
Sorry, page 423.
423, paragraph 64, and page 418 in the same authority at paragraph 14. And in that case, the wife received 7.45 million, and the judge awarded costs in the husband's favour of £150,000, which amounted to 2% of the award. And in HD and WB, if you bear with me, the reference for which is page 477, para 106. The husband was awarded £1.9 million plus a housing fund of up to 2.5 million to revert to the wife, and he was ordered to pay £120,000 towards the wife's costs, and that amounted to 6.3%, excluding the housing, of course, to revert. So those were the two authorities I wanted to draw to your attention in terms of the punitive cost point. Can I then move speedily on to the mediation?
Before you do, can I just ask you on the disclosure issue, paragraph 104 in the judgment. Yes.
Which page?
Sorry, it's page 115.
Yes,
in the bundle,
I have
paragraph
it.
104. And it's the first sentence. The judge says it's clear the husband was expressly advised by his solicitors to seek further disclosure,
Yes.
and he declined to do so.
Yes.
I'm not sure where I find the evidence to support he declined to do so. Where is that?
That was the email point, really. He didn't decline to do so. He goes on to say the husband says he was put under unreasonable pressure by the wife. I reject this admission, but he doesn't give the basis for that rejection, and we say it's because he didn't actually take into account that email exchange of if my memory's correct, is it the 8th or the 9th of June 2019.
Because as you just, this is why I picked it up in answer to my lord's earlier question. You said that the husband had the option and he chose disclosure over legal advice.
Yes.
That submission would seem to be inconsistent with the judge's conclusion he declined to do so.
Well, that's because the judge didn't refer. The judge didn't refer. There's a primary complaint of ours to any of the correspondence that took place between the husband, the wife's solicitors, the husband and wife, after the.
I think you do, but I'm just trying to understand.
Am I misunderstanding?
No, you challenge that finding.
I do.
Right.
I
That's
do.
what I thought you didn't. I just wanted to make
Yes.
sure.
Well, Miss Klein was absolutely clear in the attendance note that she couldn't advise him without any disclosure. I don't need to take you back to the attendance note. So can I move speedily on and through mediation?
Yes.
Lady, the starting point is what we would call the Dubai letter. And I don't know if your lordships have had an opportunity to read that letter. It's in the supplementary bundle. Page 557. Sent by James Berry, who of course were I emphasise, the author of the prenuptial agreement, and would have been well aware, we say, of the jurisdiction clause. I'm not going to read the letter out. Suffice to say, it was a fairly shocking letter. And if we look at the next page, it's the husband's response dealing with his belongings. But unfortunately, that threat was repeated again at page 560 on the 25th of August. We reiterate, if you do not leave our client's house by 12 noon Saturday 27th of August, she will involve the authorities for assistance to remove you from her house. And the husband had no option, as you can see, top of the page, but to leave the property. He then sought to address his belongings, and it wasn't until, if I can take you please to 562, that the husband is able to instruct expatriate law, and they write what you might think was a fairly sensible and moderate letter. Understand, so I let your lordships read the letter. And I emphasise the last paragraph, he'd prefer to engage in a more collaborative process than solicitor correspondence, whether this is mediation or otherwise. If Jenny would be open to the above approach through you to the party separation, please let me know. And the response, as we know, was from the Vice President Solicitor's plain speech on the 13th September. Again, I'll leave your lordships to read that letter. But without further ado, the wife issued a petition, and on extraordinary grounds, it says our client's instructor, sadly, because the marriage has broken down, has sight of she's taken steps to initiate divorce and financial remedy proceedings. And again, the husband's solicitors write on the 22nd of September, you go to 567, expressing how the husband was taken back at the tone of the correspondence. And at the bottom of the page, Simon's present concern is that these significant decisions are being made in a very rushed manner without giving himself and Jenny a chance to properly process matters. He'd like to offer Jenny to pause to all this and to invite her to see if there's a therapeutic path, doesn't want the relationship to come to an end. And at the bottom, importantly, I wait for your response to the above before writing substantively on financial remedy matters. And then again, the rejection by Payne Hicks Beach on 26th September. And expatriate law writes then an open letter, and I say this is an important letter from the perspective of the mediation clause in the agreement. I've now had a chance to review the marital agreement with Simon and discuss financial remedy matters with him more generally. The agreement itself is an unconventional document. It appears to have been resolved in a rushed and therefore unduly short time frame, without proper consideration being given to the correctness of form, process or outcome. Of most concern is the clearly incorrect statement of Jenny's financial position contained in Appendix A. After signing the agreement, the incorrectness of this information contained with this appendix became increasingly clear to Simon throughout the marriage. I therefore suggest we put it to one side and not incur the time and legal fees involved in debating the same, given the clear treatment the flawed document is likely to receive within the proceedings. Simon's asked to be very clear that he's not seeking to engage the sharing principle. He has no interest in causing Jenny, her family, or her family business any unnecessary upset or acrimony through these proceedings, which you inform me Jenny is insisting on. Instead, Simon is content for an outcome to focus on his relationship-generated future needs, something entirely absent from the marital agreement, but also something essential to any fair outcome. If agreeable to Jenny, Simon proposes a discussion through some sort of ADR to establish a correct amount required to meet the said needs. That would properly form the basis for a fair outcome in the present case. If Jenny is open to a discussion, she has any preferences in terms of method or how it could take place, please do let me know. And you might think that that was a paradigm letter to have been written once his solicitors have got their foot under the table, a grasp of the situation on the ground, and more importantly, a grasp of the prenuptial agreement. And it set out the same case that Mr. Entwistle ran at trial. So the response to that was a brick wall. There has been no attempt.
Sorry, where's the brick wall in the bundle?
There's no brick wall. I said the response to that was a brick wall from the wife's solicitors. There was no attempt at all to have any discussion. They were not
So
receptive.
there wasn't a response.
No. Well, I say there wasn't. My recollection was there was a rather brusque response, which was no, and the wife's response was, in fact, having issued a Form A, then to issue a notice to show cause on the 9th of November. So there was absolutely no attempt to engage in any form of discussion, despite the mediation clause. Now, one might say the mediation clause is a make-way clause, and that if the wife breached that, that wouldn't necessarily invalidate the agreement. But what we would say is, why would the wife have that in the agreement if she didn't intend to abide by it? And the husband did his best to abide by it, and you can see from the what we call the Dubai letters, the wife's total breach of that condition. Can we just briefly look at what the judge said about that in the judgment, and it's page, back to the core bundle, page 99. And paragraph 14. For her part, the wife allowed, if not caused, a remarkably unhelpful and poorly thought through letter to be sent to the husband shortly after the separation. The wife's Dubai solicitors informed the husband by letter dated 24th August the husband had to leave the former matrimonial home within 3 days or face forcible removal by the Dubai authorities. His right of residence, which had been provided by a visa from the wife's father's company as a result of his historical employment there, had been revoked earlier that month with his knowledge and consent, albeit he said felt he had no option but to give his consent as he was presented with a form to sign by the wife. The letter threatened him with proceedings for divorce and even maintenance in Dubai. Quite apart from the fact that this was a completely absurd threat when the wife had 60 or 70 million to her name and the husband had very little, this also flew in the face of the prenuptial agreement on which the wife sought to rely, which provided for an English jurisdiction clause and no claims being made by any party in any jurisdiction. And so it was that the husband felt obliged to leave Dubai, which had been his home for 9 years. His belongings were placed in storage and, as I stand, remain there this day. And then paragraph 15, adopting a phrase from Justice Mossin, but in different circumstances. When parties litigate in this faction, a nuclear war descends, negotiation becomes all but impossible, positions become entrenched and costs are incurred. Miss Bangor in her submissions forcefully blames the wife.
I think, don't read out the whole of the paragraph,
No.
but we can read it ourselves.
Did the judge deal with? Sorry, maybe you're about to come on to it, but did you say that it's not just, as it were, bad form to have written a letter, but it had some legal consequence?
Yes, if one goes to paragraph page 119, the judge comes back to this. Paragraph 126. Again, shall I just let your lordships read that?
Finding is it doesn't destroy or damage the validity of the P&A.
That's right. And we find that at, your ladyship is were ahead of me, at page 118, paragraph 124. So he doesn't deal with it compositely, that one has to dart around the judgment to collect what she said about this.
And that's the reference to the separability clause that
That's-
you say is in this reference.
It is, and can I, because I think this is quite important, take your lordship to the prenuptial agreement, and what I say is the clause that the judge is mistakenly referring to. The clause that he is referring to is to be found at page,
Clause 28, you referred us to it this morning.
that's right. It's an invalidity or unenforceability, not a breach.
What was your submission as to, again, what's the legal framework within which you put the failure to mediate and the flying in the face of the jurisdiction clause?
Well, we say they are yet further breaches of the prenuptial agreement, which clauses were included at the wife's instigation, not the husband's.
But, and,
That it
do you say that every breach of a prenuptial agreement leads to what consequence, or do you say that some breaches lead to what consequence?
But my lord,
What's the
I've thought
legal
long and hard
analysis?
about this. Plainly, if there's a breach of a disclosure clause, we say that invalidates the agreement per se.
Ab initio.
Ab initio. In terms of these breaches, in principle, they should invalidate the prenup because she is the wealthy party.
That's not normally the contractual analysis. If it was it's something vaguely akin to a contractual, you say invalidate. What do you mean invalidate? Not ab initio.
No, because it came at the end of the marriage.
Yeah, but I mean,
But
are
it
you
was
saying in
court.
effect this is a repudiation of the, putting it in terms of a sort of, I know it isn't a contract, but let's put it in some sort of framework. Are you saying this is akin to a repudiation?
I am, my lord. But your lordship has the word, I've called it breach. I think repudiation is a more accurate reflection.
Right.
Because at the very end of the marriage, we might have avoided standing in this court if the wife had abided by the mediation clause. And indeed, his lordship does actually more or less say that if one goes back to his judgment. It's the nuclear winter.
waste.
And if we go back to also paragraph 8, when the judge says it's a paradigm way of not litigating. And if we go to paragraph 14 at page 99. And leading on to paragraph 18, which I say is important. So it was after this short marriage where the exit should have been easy, cheap and obvious. The parties were at loggerheads, opposite positions having been taken, trenches dug and a long cold winter anticipated. In this case, the wife had and has the luxury of infinite resources. The husband has had the benefit of enjoying the trappings of being married into a family of exceptional wealth. And I am certain as I can be.
And I was going to ask, sorry, I mean, we don't need to hear this, but I mean, you did put this to the judge. the repudiation point. I'm just looking at page 178 of the supplemental bundle. I'm just trying to understand whether the judge didn't deal with it in the way you're now putting it because it wasn't put to him. But in fact, I think you did, didn't you?
Now just find page 178.
Yep, you do. No separation conduct, series of repudiated
Yes.
breaches, despite having the benefit.
And they go to the heart of the PNA.
Yeah.
So,
I think I actually did use the word repudiation.
yeah, well, sorry, time is short, but I'm just trying to get a
Yes.
legal grip on what you're saying.
Yes. We might not be here now if the wife had triggered the mediation clause and there had been a sensible roundtable discussion based on the husband's needs. And that was in part recognised by the judge in his judgment. May I then move on to needs because I'm very conscious of the time. It's perhaps stating the obvious to the court, but it's well established that even in circumstances where there are no vitiating factors, a prenuptial agreement can be departed from in terms of the assessment of the needs on a generous basis. And my lord, I can take you to the relevant authorities.
Well, we have your paragraph 90 onwards. We've got your
That's right.
skeleton
So I
argument.
can move on. What we say in terms of the section 25 factors, and I intimated this in opening this morning, was that the judge did not assess the husband's needs as against the section 25 factors. There were no references at all, as you would expect, and it is common in judgments of this nature, any proper reference to the length of the marriage. And in fact, in this case, the judge, as we will see, incorrectly recited to himself on numerous occasions in the judgment, which we say played on his mind the brevity of the marriage. The standard of living was en passant, as it were, in the early stages of his judgment when referring to the husband enjoying the trappings of exceptional wealth. Contribution doesn't feature at all, whether factually or otherwise, and the only factor that he did take into account was my client's mental well-being, and he made provision for that. So in terms of the length of the marriage, what the judge did was correctly recite himself as to the length of the relationship, and that is at paragraph 30 at page 103. And cites the RWTW test, and he says, when considering cases of this nature, considering section 25, the length of the marriage, it's generally the custom now to add to the length of the marriage a period of premarital cohabitation, which has, to use the well-worn phrase, moved seamlessly into marriage. Well, when we actually come to look at the judgment, again we've set this out in our supplemental skeleton argument, there are numerous references in the judgment to this being a short, childless marriage, and it becomes a mantra throughout this judgment. I don't know if it would be helpful if I took you to each of those references, but it was certainly, this was a short marriage, it ended after a short period of time, the marriage and relationship was short. It was a short marriage.
Even with the 5 years.
I understand, but it's not very short, lady. We are used to dealing with short marriages that may last 6 months or a year or 2 years. This was a 3-year marriage preceded by a 3-year relationship, so 6 years in all. As to the standard of living, that seems to have not been weighed in the balance at all when the judge was dealing with needs, and he seems, or doesn't even refer to the fact that at the time of the separation, the parties were living in a £4.5 million property, what is described as a mansion villa with 5 bedrooms, 9,000 square, the house occupying 9,000 square feet. He again deals in passing in the early part of the judgment with the exceptionally lavish holidays that the parties enjoyed, the first-class business travel, designer clothes and jewellery. But does that actually come into play when he considers, we say, the critical omission in his reasoning, the reasonable needs of the husband? For assistance in this, you have a schedule which I have sought, as it were, to encapsulate what the husband's assets were, the needs assessment, and then the net effect.
Is this the one that was sent through? during the
I handed up this morning, and then your ladyship asked for them to be sent electronically.
Yeah, but it didn't come just that document.
No,
Number of other documents.
Your
Okay.
ladyship also asked for, I think, the prenuptial assets schedule, which was handed out.
Yes.
So those are the 2 schedules that have been sent to your ladyship
Okay, thank you.
electronically.
Now, I'm concerned that you have not addressed what you said was your prime target on needs, namely property.
It is. So can I presume that this is?
Yes, we've read.
This
we've
is
got
read.
It. Mr. Lord Fawkes can submissions he wishes to do about it. But I would just like to have your key submissions in about 2 minutes on the property.
Our key submissions is that the husband lived with the wife, first in her flat, and then in a substantial property which was substantially improved throughout the marriage. And so at the time of the parties' separation, they were living in the mansion villa worth 4.5 million. But the judge did not consider it appropriate to even contemplate whether or not there was a prenuptial agreement. He says so himself in his judgment, that the husband was entitled to, as part of his needs assessment, to have a property. What he did find is that the husband was entitled to go and rent a property, a 3-bedroom service apartment, for 1.75 to a value of 1.75 million pounds, and so that gives some indication, we say, as to the level of housing he thought was appropriate for the husband, taking into account the value of the family home. And we say he was right to accept that as a indicative housing figure, if only for rental purposes, because even that property was 1/9 the size of the family home. Well, the property particulars, forgive me, put forward by the wife were 1/9 of the size of the family home. They were in old tower blocks in inappropriate areas, and he had put a great deal of research into the type of property that would be suitable for him. And the emails from the property agents, I don't know.
We've got those. I think the key, what I'm more interested in is not the property particulars, because you say 1.5 seemed like a reasonable indication because that was going to be the rental. I'm much more interested in why you say the judge was wrong on the needs analysis not to order a lump sum of 1.5 in addition to the other features of a needs case.
Can I turn this round and say, if we were looking at a wife who at the end of a 6-year relationship, who had been utterly reliant upon her husband for housing, who had married, as it were, into wealth, it would be highly improbable that a court would have expected her to get on her own 2 feet after 2 years in rented accommodation. And this is where we say the gender discrimination really came into play. Because this was a husband, who we've already seen, was ejected effectively from the home, ejected from the country where he'd resided for 8 or 9 years, and left with nowhere to live. And it was accepted that he was entitled to return to Dubai. And in my submission, if this had been a wife, a judge would have had no hesitation at all in providing a housing fund.
Okay,
It
thank
didn't
you.
matter that it was a short childless marriage, it was a 6-year relationship, and that kind of property, in my submission, was entirely consistent with the standard of living and the standard of housing that the husband had enjoyed during the marriage.
Thank you.
I think the relationship is telling me to sit down.
I am.
I think.
Very perceptive.
Before you do, just one question. If we get that far, are you seeking a rehearing, or are you asking us to decide the needs issue?
I'm asking your lordship to decide for this reason. My client's appeal has been run, as you probably gathered, on a shoestring. His Salford flat is on the market because he is running out of funds. If there were to be a rehearing, there would be further delay. He wants to get on with his life. His life has been on hold effectively since August 2022. You're aware of the significant health difficulties. I'm not going to go into detail that he's endured. He wants an end to this case. The costs of his appeal, I think, are around £120,000, which he can ill afford. And he would like your lordships to determine. I did take this up with him before the hearing because I anticipated it was a question that I might be asked. So he would be content for this court to determine those needs. What he can't brook is further delay and further costs, which he simply can't afford. That's what it boils down to.
My Lady, my Lords, this appeal is advanced on the basis that the judge was wrong to give effect to the prenuptial agreement, and that in any event he was wrong in the assessment of the husband's needs. So the initial question must be whether or not there can be any challenge to the judge's findings in relation to the prenuptial agreement. And the court will be acutely aware of the fact that we have the benefit of detailed written submissions at the outset of the trial and at its conclusion. They're in abundance. And that of critical importance, he heard the husband and wife's oral evidence, which supplemented their already lengthy witness statements. And both were subjected to lengthy and very skillful cross-examination. But the judge came to some clear conclusions about the evidence and as to questions of honesty. And therefore, it's not clear to us the basis on which the husband can reasonably challenge the judge's conclusions on the facts. We submit he directed himself in accordance with the law, in particular Granatino and Radmacher, and his findings were essentially ones of fact. And as to needs, and I'll say a little more about the approach to needs in a moment, that's essentially the exercise of a discretion, and in the words of many judges, it's more or less an appeal, unless the judge can be said to have misdirected himself in some material way. And also more generally, the law is clear as to the circumstances in which an appeal court can interfere with findings of this sort. It's perhaps not necessary to elaborate too much, although the approach has been very well expressed in the case of Piglowska, Reby and Fage and Chobani, and I'll very briefly take you to the relevant passages in due course. If the court is not persuaded that the judge was wrong, he misdirected himself on the law, we remain, a lady, unclear as to how it seriously can be argued that he did, and how can the court interfere with his findings in relation to the prenuptial agreement. If that's the position, it follows that the court may be left with an argument exclusively as to whether or not the judge's findings as to needs can be challenged. Once again, we refer to the well-established principles, which mean that it's extremely difficult to challenge a finding on needs, unless the judge misdirected himself on the law or fundamentally misunderstood the evidence in some way. Well, anyway, my lords, the judge expressed himself as having been generous, and that was his adjective, in his assessment of needs. Our case is that if he was, if anything, over generous. But even if the court were to conclude that he had not been particularly generous, that does not mean, we submit, that this court should interfere with the assessment. How are needs to be assessed where there has been a valid prenuptial agreement? I use valid in inverted commas because, of course, the nature of a prenuptial agreement and how the court should respond to it is very specifically addressed by the Supreme Court in Radmacher. There was some dicta of Mr. Justice Mostyn in a case called Ibeki, which is in the bundle, Appeals Authorities Bundle 339, which suggested that needs might be regarded as needs whether or not there was a valid prenup. In other words, that a court would assess needs in the way that it would normally do when considering its discretion under Section 25 of the Matrimonial Causes Act. But his comments were very much in the context of considering the Supreme Court's observations in Granatino about a predicament of real needs, the expression that's used in the judgment. And we need very much to look at the context of his comments. But he did in fact row back somewhat from those comments in the subsequent case of Cummings and Fawn, which the learned friend took you to, but not the passage that I would like to highlight, where he used a bookshelf analysis or bookend analysis, emphasising how much discretion a judge has in considering needs where there has been a valid prenup. And referring in particular to what the Supreme Court had said in Granatino. Where there has been a valid prenuptial agreement, the court ought, when assessing needs, to have in mind as a crucial part of the analysis the fact that the parties had chosen to determine how assets should be divided on divorce. The respect for the parties' autonomy is crucial. There may be circumstances in which a court, when assessing needs, even where there has been a valid prenuptial agreement, may go so far as to make some order in relation, for example, to a house, which on the face of it is not consistent with what the parties have agreed. The learned friends give examples by reference to decided cases. But we submit all of them are determined very much on their facts, almost always with longer marriages and the involvement of children.
But sorry, your primary submission is that the fact of the existence of, as you term it, a valid prenuptial agreement is relevant to the assessment of needs.
Yes. It appears from what, and I'll take the court to what the Supreme Court said, that it's a part of the analysis of a prenuptial agreement. And our submission is that, properly read, what the Supreme Court was saying was that if the court is of the view that there is a valid prenuptial agreement for the reasons they give, then unless there is a predicament of real needs, that may be the beginning and the end of the story.
To a contrary, if there wasn't a valid prenup, then would an assessment of needs, which was done on the basis that there was, be flawed? I don't entirely accept the relevance of the question, but if one looks at the way the judge approached this case, and we'll come to that if I may in a moment, he actually directed himself according to Section 25. He doesn't appear to have actually used the expression predicament of needs, which is a particularly Radmacher type consideration of needs. He addressed the question of needs almost as if the prenuptial agreement had not been there. The question perhaps that follows from what my lord has asked me is, what is the status of an agreement which, for one reason or another, a court might decide is not as satisfactory as it might have been? Because, of course, although one looks at it as a contract, it isn't an enforceable contract in the way that a contract would be in common law. But nonetheless, it has strong... But if it's vitiated in the, to use the expression that was used in Radmacher, if it's vitiated in one of the ways that the Supreme Court identified in Radmacher, and the judge gets that wrong and thinks that it's valid and goes on to assess needs against the background of a valid prenup, he's almost inevitably going to be doing it wrong, isn't he? Assessing needs wrongly, because he's effectively, especially if it's a drop-hands prenup,
He might be. What we would submit on these facts, he didn't, in fact.
Okay.
But he might be. Of course, our primary submission is that he was right to actually say this was an agreement that should be respected, is perhaps the way to.
Oh, yeah, I know that's your primary point. We're just
Yes.
talking about.
Absolutely. What would be the answer? If one could see that his analysis of needs had been infected or by the fact that he concluded that there was an ineffective agreement, or is coloured by it, then I accept there may be some force. But of course, if one looks at the facts of this marriage and what would be the needs, then we submit that his analysis, even in the absence, there'd be no agreement at all, let alone one which had been decided, attempted but this year, just no agreement. His conclusions on the needs was in fact a generous one, given the length of the marriage. And he doesn't, in our submission, have to ignore the fact that these were people of a certain age. One of the husband had a history of previous marriage. He had a job, and they entered it, as it were, showed every inclination of being, as it were, partners in the non-partnership sense. So we submit that in this case there was no reason to deviate from the prenuptial agreement because it had been short, there were no children, and although there was always a significant disparity in their relative wealth, it's not as if the husband was rendered destitute or would be rendered destitute by the order of the judge. I mention that because that's one of the factors that's discussed by the Supreme Court in Radmacher. And insofar as his resources were reduced by his refusal to accept reasonable offers, that is not a matter which would entitle him, as it were, to top up compensation for his wasted legal costs, as was helpfully considered in a number of cases, including WC and HC, judgment of Mr. Justice Peel, and indeed in my Lord Justice Moylan's judgment in TT and CDS. We submit this case is a very clear illustration of the circumstances in which a court should be very reluctant to depart significantly or at all from what the parties had agreed. In essence, the learned friend's arguments are that the husband enjoyed a very high standard of living with his former wife. Following the judge's order, he will no longer be able to enjoy such a standard of living, and his needs claim, so she says, ought to reflect this. There is also a specific argument as to the size or quality of the matrimonial home. Was it such an order that the court should order, and this is, I think, the case for the husband, a substantial amount to allow him to be housed in Dubai in property broadly commensurate with the housing that he occupied together with his wife, or at least in much better accommodation than he had when they first met. And we reiterate that there were no children at the marriage, that he had his own rental property before marriage, and he retained property in Salford, although I understand from what my friend says that is on the market, unless he had somewhere to live. In those circumstances, given that he did not contribute to the so-called matrimonial home, this was in fact given to his former wife 2 years into the marriage by her father. This wasn't, as it were, a joint enterprise from the start, where they both put in deposits or the entire cost of the matrimonial home. It's difficult to avoid thinking that the burden of the submissions appear to be that, notwithstanding the prenuptial agreement, since the husband was marrying into a rich family, somehow the court ought to reflect that fact in its assessment of needs, notwithstanding the prenuptial agreement. And the court may not be very impressed by his original suggestion of a £10 million payout.
I don't think either of them covered themselves with glory at the beginning.
I think that's a fair observation. And certainly the Dubai letter was not one which...
Well, it was disgraceful, but
yeah.
Similarly, seeking £10 million was a nonsense. And I think
I accept
the
both.
wife accepts it was disgraceful and the husband accepts it was a nonsense. So I'm not sure I'm going to be helped by further analysis.
Very well, I will move swiftly on. It may be worth considering, though, what a court might have ordered the wife to pay him on divorce, even in the absence of a prenuptial agreement. Why should she be considered to have a liability to subsidise his earnings? Why should she have an obligation to buy him a property in Dubai, or indeed any property, why should she pay his medical expenses? Although it's unnecessary for the court to carry out a theoretical Section 25 exercise, it's a useful cross-check and may lead to the conclusion that the end result of this case is not actually of significant variance to what a court might order under an ordinary Section 25 assessment of needs, even in the absence of a prenup. My Lady, my Lords, there are, of course, significant public policy factors at play in this case. The Supreme Court finally acknowledged the significance of prenups in Granatino. It might be regarded as unfortunate that the legislature has so far not intervened, either to adopt the recommendations of the Law Commission, or at least to produce a bill which reflects some of their recommendations. We submit, however, that if this court interferes with the judge's decision, there must be serious doubts as to whether Granatino has achieved very much in terms of avoiding exactly the type of long and expensive dispute which is taking place here. And it is worth looking at certain parts of the prenuptial agreement, and they echo, the court may think, what reasonable people entering a marriage in these circumstances might want from such an agreement. And consideration of the chronology in this case shows how such aspirations have well and truly been frustrated by this litigation. And our submission is that this court should consider making it clear that prenuptial agreements will, unless vitiated by lack of consent or other reasons for deciding that they should not be honoured by the court, be respected by the courts. And in the absence of a wholly wrong assessment of needs, there should be no appeal from a first instance decision, if, sadly, a case has not been taken to compromise before reaching the court. The learned friend made much of the failure to mediate. I think I can deal with that fairly briefly. There were huge problems in the marriage. I think I'd better leave it there rather than go into any detail, which is unnecessary, because conduct's not an issue in this case. There was an FDR, there was no settlement. We don't go into that, of course. There were various letters in which
Requests for round tables which were refused.
That is true. Of course, the situation had been that the parties were sadly somewhat at odds with each other, and I'm not asking this court to come to any decision as to who was right and who was wrong. As the judge himself said, mediation is certainly a good idea. It can and often does produce a satisfactory result. But to say that in these particular facts, the failure to mediate somehow undoes or unravels the causes of repudiatory breach, as it were, if this were to be an agreement, that we submit as a submission too far.
What the judge decided in paragraph 18 of his judgment was that he was as certain as he could be that had different positions been adopted from the start, the case would have been resolved. So what do we take from that? Sorry, this is the end of paragraph 18 of his judgment, the last sentence.
Well, I mean, he says, I'm as certain as I can be that different positions have been adopted, would have given a bit, the husband would have given a bit, and the case would have been resolved. I can show the court two letters, which perhaps rather than going through the entire correspondence, which show that the parties were very clearly apart. So although that's the view he took, he probably wasn't aware of all the correspondence in that respect. And of course, it's always desirable that the parties should come to terms. But I think this court would be, with great respect, going too far to suggest that any side was at fault in failing to come to a satisfactory conclusion in this case. There are all sorts of factors about which this court may not know, which made it difficult.
No, it's not. It's more that it was his reference to, in a sense, that well, not in a sense, what he says, that had the parties adopted different positions at the beginning, which includes
both parties,
the failure to go to mediation.
Yes, although he did in fact deal with mediation also and did not consider that to be a significant factor. He did not accept that as it were. Yes, it's paragraph 125. That's right. paragraph 125 at 118.
Yes.
I'm not going to allow myself, as a second sentence, to descend into claims and counterclaims of what went on in the marriage, for to do so would fly in the accepted wisdom to which I've already referred. The court should do all it can to avoid, in many cases, descending into the arena of the day-to-day struggles of the couple's relationships. It's, however, abundantly clear the relationship was a desperately low ebb. And goes on to say that. And then concludes, however, the wife said, and it is difficult to see how mediation could work in the face of a marriage which ended with a level of acrimony, mistrust and anxiety that both parties agree was present. Even the most experienced mediators will say there are some cases which are profoundly unsuited to mediation. It seems to me this case may very well have been one of those. So in some senses, that's slightly at odds with the paragraph to which
Yes.
my Lord
Thank you.
And also, and I don't think we need to take this thought
Very
further, Lord Fawkes, but the fact remains that it was the decision not to mediate was done with unseemly haste, and very often mediation takes place when things have cooled down a little bit, and the initial separation, everyone's got to come to terms with the initial separation, and certainly the correspondence we've been taken to so far, the husband's team, some significant time after the immediate separation, was still hoping to achieve an outcome that did not involve all of this and the desperate impact it's had on these two young people.
As a general principle, I entirely accept that. Of course, the judges who expressed himself in that particular paragraph followed an assessment of both parties, giving evidence over a long time, which enabled the judge to understand the family dynamics here and the individuals. He made assessments of them. And it may be that coloured his conclusion that whilst I entirely accept what the lady says about mediation in general terms, there may be some cases where that is difficult.
Well, thank you.
Can I take the court now to the prenuptial agreement? I know that the court
So
has...
are you going to at some point deal with the question of repudiation?
Yes, of course. I mean, in general terms...
Don't take it out of your way, because since we're at paragraph 125, it's the next paragraph.
Yes.
26 I wanted to ask you about. But if you're going to come back to it, then do so in your own course.
Yes, I mean, the problem about repudiation is that in the language of contract, of course, one looks at a breach. Is it a repudiatory breach as a result of which a party is then relieved of further obligations? Is it a breach of warranty which might sound in damages only? Although, of course, it's helpful to analyse a prenuptial agreement.
I'm not trying to bring make it very clear. I'm not trying to bring. I just used the word because it's the one that we understand.
Yes.
But in paragraph 126, the judge accepts that the threat of divorce proceedings and claim for maintenance in Dubai and the matters we've just been talking about, in his own words, flew in the face of the prenuptial agreement which the wife herself wanted to rely on. He says it's an extraordinary own goal. And then at the end of the inappropriate threat, stupid threat, wrong. And then at the end he says, it doesn't, although it's a desperately unhelpful way to start proceedings, it doesn't destroy or damage the validity of the prenup agreement in my judgment.
Yeah.
Now, he's not really grappling with the point that was put, which is that this is somebody who wants to try, on the one hand, to rely on an agreement as having some force in subsequent proceedings like now. But on the other hand, effectively acted in such a way that quotes flew in the face of it. It's did the judge explain, failing to sort of grapple or explain what he seems that seems to be it. It doesn't seem to be anything else. He doesn't really seem to grapple with the point.
Well, let me endeavour to try and not read too much into it, but try and explain what I submit is the significance, if any, of this. Now, I'm not suggesting for a moment that was anything other than an unwise thing to do. I think I've conceded that. And, it's common ground. Before those instructing me were involved, it was an aggressive letter and should not have been sent in those terms. The question, though, is what happens after divorce in relation to the division of the assets between the parties. Nothing about that behaviour goes to the root of the contract which the parties made as to what should happen on the division of the assets. So it's a piece of behaviour which is regrettable, but it doesn't go to the root of the contract, to use contractual analogies. And we submit that because there was this bad behaviour, aggressive behaviour, it doesn't cause the court to say the contract therefore has no validity. It's not. It doesn't go to any particular party. That's my submission. And what he was saying in shorthand was, does not destroy or damage the validity of the prenuptial agreement, his judgment, because he's not shying away from the behaviour. He just says it doesn't affect, in his view, the validity. And if one looks at the agreement itself, which I was just coming on to do, one can see that it shouldn't, in our submission, undermine what the parties had agreed or what the court should decide when considering whether or not to honour or reflect the terms of that agreement.
Thank you. So, you want to turn to the document?
Supplemental bundle 1, 245. I'm not going to repeat what my learned friend has already taken you to, and I know the court would read this very carefully, so excuse me, I'll just highlight 1 or 2 points.
Can I just get the page number again?
It's 245, supplemental bundle 1.
Back. I'm off my screen, I'm afraid.
Oh dear.
Right, yeah.
245, it sorts the important notice: do not sign it unless bound by its terms. Do not sign it unless you've had independent legal advice which you understand and with which you are satisfied. If we go to page 248, it was made in consideration of the marriage. This is whereas. And B, whilst Jenny and Simon are not joint parents of any children, they may want to have children during the course of their marriage. And the terms of this agreement are intended to reflect that decision. I'll come to a little more on that. D, Jenny and Simon hope and intend their marriage will endure. However, they recognise there exists the possibility that marriage may break down. They may wish to separate and they may then wish to be divorced. Following discussion between themselves and the financial consequences of their marriage, including the financial consequence of their marriage breaking down, they wish this agreement to limit the ambit for dispute between them. So sad that wasn't possible. They do, and this is important, acknowledge, there is a disparity between the separate property assets in Jenny's favour. And then during the subsistence of this agreement, it's not their intention that either of them shall acquire any rights over or interest in the assets of the other, nor do they intend to make any claims against the other in any courts, in any jurisdiction. And it is their intention that no other or additional provision for income, maintenance, capital, property transfer, settlement, distribution, or other provision of entitlement consequent on the breakdown should be made either of them in court in any jurisdiction of the world. They do then provide this clause is effective until the occurrence of any events in paragraphs 29, A, B, C, and D below, which I'll come to shortly.
So the letter written by the device solicitors was, you said that the behaviour didn't go to any term of the contract. I mean, that's the first one it does go to, doesn't it?
Well,
they said, under Dubai law, and we're going to institute proceedings, you, husband, have to make provision to maintain life.
Yeah.
That was their claim. I mean, that's just flat contrary to F, isn't it?
It's certainly completely inconsistent with that. But the question is, does that, as it were, threat or letter undermine what this contract says? If we say it doesn't.
Well, why doesn't it show an intention not to be bound by the terms of this contract? In the sense that solicitors are writing a letter saying on behalf
we're
of
not doing it.
on behalf of their client.
On behalf of their client.
Everybody has to take responsibility for the letters their solicitors write.
The finding was that your lay client had read it.
Yeah, the finding was that she'd read it. It is trying to preempt the whole business. I submit that that does not undermine the whole contract, although I absolutely accept that on the face of it, by seeking to invoke Dubai law, it's not consistent with what is contained in paragraph F. But does the court then conclude that from that letter it should disregard this agreement as a whole, which is to do with after divorce, what should happen with the assets of divorce? I would submit not, because apart from anything else, of course,
The agreement's not just to do with assets, is it? I mean, that's the whole point. We just looked at a clause which is not, quote, just to do with assets.
well, it is essentially to do with assets, because although there's a reference to children, when we come to clause 29, we'll see that what that's saying is that there may be necessary to revisit the agreement in the event of children. And can I come to that in a moment? I'm just before I do, so that I keep going in chronological order. Page 249, Jenny and Simon have entered into the agreement freely and voluntarily without undue influence, duress or coercion. Then the learned friend referred you to J, and it says that he does not wish or need to receive independent legal advice, although, as we know, he had consulted solicitors who had given him some, according to the judge, because privilege had been waived, good advice. That's what he determined. Then at page 250, construed Q, construed as a jurisdiction clause, and then under full disclosure, they fully and correctly disclose to each other their financial resources. And then importantly, S, both Jenny and Simon recognise that the other is not completely detailed, but each acknowledges that such disclosure has been substantially complete in all material respects. On this assumption, they each voluntarily and expressly accept the disclosure provided by each other as being sufficient to enter the agreement. So that goes very much to the materiality point made in Radmacher. And they both waive any rights to further disclosure or inquiry. In particular, Jenny and Simon have not sought to have and do not wish to have any further valuations of the various assets, which they did put in. And then,
Sorry, but are you going to come back to S? I mean, the assumption is falsified by what actually happened.
in what sense?
Well, on the assumption that the disclosure has been substantially complete in all material respects. On that assumption,
Yes.
I mean, if that assumption is falsified by what happened, then this clause doesn't operate, does it?
Well, except that they've waived their rights to any further disclosure. I think what your lordship's saying is that if you were to look at the substantially complete, and if it's not substantially complete, then you say you're suggesting, perhaps, my lord, that it undermines the rest of the clause.
Yes, because it's especially predicated upon the assumption that there's been substantially complete in all material respects.
Well, substantially complete in all material respects is, of course, what they needed to know. It is not, and he knew, as we know, that she came from a rich family, that her father, as it were, had considerable control over assets which were in and out of her property. And the question is, would it have made any difference, whether it was 20 million or 50 million or 70 million? So that the question of substantially complete in all material respects means he's disclosed the fact that there is a significant disparity in wealth. Because, my lord, it's not the case put forward, as I understand it, by the learned friend that...
But hang on, this is a reference to the disclosure referred to in R in Appendix A.
Yeah.
I mean, it's not... The agreement doesn't just say, wife is
very rich.
Very rich. That's all you need to know. I mean, that's not what this agreement says, and it's not what it purports to do, and it's not either the basis on which the husband agreed not to seek legal advice.
Well, I'll come to that if I'm in a moment to answer that question. But so this is what it actually says was they both waive any rights to further disclosure or inquiry, so that the
that's on the basis of the disclosure.
I'm sorry, Lee?
That's on the basis of the disclosure that was given.
Yes, but on the other
And the
hand,
disclosure that was given was virtually none.
it was.
And he his the wife's solicitor wrote a very proper letter to the husband saying you need to have full disclosure. The husband then was presented with the option of either having some disclosure or having disclosure of the appendices and no legal advice, or no disclosure if he had legal advice. And he opted for the no legal advice but disclosure. And then he didn't get the disclosure. So he had no legal advice and no disclosure.
I'll come to the question of legal advice perhaps when I look at the actual advice that he did receive. There is and whether it's substantially complete. Of course, I accept that the schedule does not contain a great many of the assets which at least were in her name, probably in her name, and the judge dealt with that. But it still does down time.
I mean, let's be clear, her assets.
Yes, in her name.
Her assets. She owned the assets.
Yes, I mean, whether or not she would have done what our father told her to do in relation to the assets is a matter that was explored in the evidence.
No, I don't think it is. I think what was said was that he obviously had influence over the companies.
Yeah.
And she was the owner, and indeed had to be, I think, probably for estate, for inheritance tax planning purposes, of shares. I'm not sure that, with all due respect to the cross-examiner, I'm not sure the cross-examination is quite as you characterise it. I mean, yes, she said, yes, I would have signed documents if they were put in front of me because I trusted my father.
Yes. Perfectly
Understandable. I don't find that cross-examination remotely surprising. Oh, sorry, the answers that were given remotely surprising. But I think we've got to get away from the idea that these were really his assets still. I mean, the assets that were not disclosed were her assets and were intended to be.
Well, I hear what George says. I'm not sure that I can insist very much further, except perhaps by looking at the advice he received and reverting to the point, which is what was material in terms of entering the agreement, because the agreement was effectively a drop hands agreement. So we do revert to the point that we make in the skeleton, which is that actually the extent of disclosure, although of course I absolutely accept that it certainly, as I think one of the judges said, the gold standard, there should be full disclosure. The question is, was disclosure sufficient to make this an agreement which was entered into freely? And we submit that, as the judge found, was the case. And they did say do not want any further valuations, for example.
Well, I mean, we see cases, don't we, with prenuptial agreements where there's an indicative value and everyone's happy to work on that. You get cases like Radmacher,
yeah,
where they say, no disclosure, we don't need it, we're putting it away. So presumably, this wife could have done all her meetings with her lawyers and with her father present, could have given a list of her shareholdings without any valuations. She didn't. She wholly failed to disclose nearly £50 million worth of her assets.
I take your
Circumstances was the deal. You won't have any disclosure if you insist on legal advice.
I will come back to answer that point directly, but can I look at the legal advice that she actually received? Because I think that will help.
The legal advice who received? He received.
Yes.
Sure.
Before I do, I just want to look at the agreement on the family home, which is at page 252.
Thank you.
In the event of the divorce of Jenny and Simon, any jointly owned property occupied as the family home prior to their separation should be divided between Jenny and Simon in the shares that the parties contributed at the time of the purchase. Of course, there was no contribution to the purchase from him, as we know. And at 255, can I finally take, while looking at this agreement, look at the duration of the agreement? which is this: the terms of this agreement, clause 29, shall be reviewed with the benefit of independent legal advice when whichever of the following events shall occur. In the event that either Jenny or Simon choose not to vary or cannot agree, then the terms of this agreement will continue its present form even after the relevant event has occurred. And then they have 5 years, the birth or adoption of a child, or a period of serious ill health in excess of 6 months. This is perhaps particularly relevant because one looks at Radmacher, they talk about those sort of circumstances which may cause a court to decide that the agreement should not be enforced. I think what a lady is really suggesting is that they would be better off really not to have had any disclosure at all.
I'm not. I'm just saying that you can make choices about
Yes.
how you're going to tackle disclosure.
It's perfectly true.
And if you decide there's going to be disclosure, then you disclose.
I absolutely see the force of that argument. If they had simply said, we're not going to have any disclosure, you know that I'm a wealthy woman.
And then he could have taken the advice, and his solicitors could probably have said, "I'm not signing off on that." Then, and he could have chosen whether he did or he didn't.
Yes. But can I take you to what he was advised and what, which is at 264. This is on the 15th of May, 2019. It's the same file. This is Judith Klein saying, no, you want a high-level review, hands slightly tied in terms of detail, can advise on detail but not on impact, have no figures. As he's saying, Jenny and father agreed prenup as he is engineer, is working for Saudi family and moved to set up business in Dubai. Also has hotel business. The appendix is very sensitive. So this is coming presumably from Simon. Everything has been done through courier.
Sorry, whereabouts are we?
So we're in the first paragraph of the attendance note.
Sorry, yes, I've got it.
Halfway through, everything has been done through courier and don't want anything on email with assets. JK saying limited advice as cannot tell impact, has have no figures. And advise further with appendices. As he say, can give approximate figures. JK can talk about general first. Generally, prenup is not legally binding, but the law is heading that way. The more likely to uphold, will definitely strongly uphold if the parties know what they are entering into and sought advice. Even if no advice, if found capable, intelligent adult with no duress, likelihood to be held to its contents. Asking, what are you trying to achieve? Says, saying, idea is to walk away with what brought to marriage in respect of existing assets. Joint assets will be divided. Hopefully common sense will prevail for small items, more about protecting wealth in Jenny's name through her father, not bringing level of wealth she has, but also not empty-handed. Agrees that it is best for both parties. JK saying agreement ring fences anything Jenny brings in. In the event of divorce, will not cater to needs. Without disclosure, do not know assets. Question whether we can stand on our own 2 feet in event of divorce. If not, this will be limiting, as we would walk away with what came into marriage. Consider, this is obviously advice, if financial position is strong enough as an individual, saying, and then he goes on to say he's no longer working as assets with no salary.
It seems to be a mixture of, it's unclear, a little bit unclear as to whether this is a mixture of what he's telling the lawyer or what the lawyer is advising him.
Yes, I mean, I think it's reasonably clear that where what is advice and what he's saying, as it were, about their family setup. In the event of divorce will not cater to needs, for example, that seems most unlikely to come from anything other than a lawyer, because the concept of needs, of course, has a very specific meaning.
Yeah.
Without disclosure, do not know assets. And then she's dealing at the bottom of the page. JK saying important stuff is that separate property is ring-fenced. One concern on your behalf, it says during marriage, separate property held by Jenny shall remain in her name, notwithstanding any contributions. Then money is hers, unless record by deed that it becomes joint. He's saying, assume works both ways. She refurbishes my home, stays in my name, yes, but assets are heavily weighted in her favour. Concern is restriction on you. Contributions will not be taken into account, need to be comfortable with that. And then if we go to the next paragraph, I'm not going to read out the whole of this attendance note, but it is worth considering carefully. And the judge did consider it. The penultimate sentence, JK saying clear will not get it in anything of hers. And then the following paragraph, the penultimate sentence, JK saying, appreciate that, but both people can change on divorce. You need to be happy with worst case scenario. Been asked to qualify and to purchase contributions. And then he says, confused by paragraph 13, seems family home will be dealt with differently. Then sets out the same will be divided in accordance with contributions. Just wondering redrafting, wondering equal shares, but agreement reflects as per contributions as long as you are happy. Again, concern re-improvements to family home. And then the last paragraph, provision upon divorce, reiterates how things to be dealt with. Joint assets, any joint accounts will be closed and divided in accordance with contribution. Practically cannot figure out contributions, common sense would say. The rest is to agree binding and dismiss financial claims. Need will be in 12 months, as well. Saying already doing that. JK paragraph 29, that's the paragraph referred to, ability to review up to 5 years. He asked, can I amend at any point, saying no, once binding, signed. Can add mutual consent to vary. Suggests that trying to think why would amend. Asking can vary by agreement on divorce. Yes, but enter this assuming how it is dealt with. Do not assume can get out of it. So pretty firm advice that he's receiving. 266. JK saying confirms Hallbrown acting and advising given high level review, not seen appendices, and not comfortable signing that, can still sign without legal advice. Saying in appendix just list of assets. JK saying depends on the level of disclosure you want. Accepting not crystal clear, just overall understanding is looking to the future. And then the essence of it, and this is about 5 lines up, SE saying understand, previously had prenup on divorce, asking redocumentation, negotiation. And then the final sentence of that paragraph, normal to ring fence separate property, joint property values. JK saying you feel like would need more protection than need to think about it, but saying comfortable. SE saying yes, comfortable, saying good to go in with eyes open. So this is, as the judge found, some very sound advice about the consequences of signing this agreement.
I'm not going to ask you to read it all through, but I do think that you'd need to read the anti-penultimate paragraph on 266 in full.
Yes, I'm just rushing through it because of time.
I understand that,
and I'm not trying, as it were, to brush over any part. But I think what I can say is it is a fairly thorough piece of advice, and the judge's conclusion on that advice is not one which I think can be criticised.
You didn't take us to the bit where the lawyer said she needs to see the figures in full agreement.
Yes.
Full comments and be involved with negotiations with the lawyer, would need to communicate with lawyers and review the appendices.
That's absolutely correct. The judge refers to that. And clearly, if you were a lawyer acting, you would want to see what was in the appendices before thinking you've done your due diligence in advising the client. But ultimately, don't forget, this is a man who's got an accountancy and law degree, who's been married before. It's up to him.
Well, that doesn't help if you don't know what there is.
I'm sorry.
That doesn't help if you don't know what there is.
No, but it's not the, as I understand it, the claim, the husband's case, that had he known that there was a lot more, his approach would have been different. Because essentially what he's saying is it's a drop hands arrangement. What we came in, we came out with. So the quantum, and I absolutely accept all the comments that we made about the level of disclosure in the appendices, the quantum is not material.
I mean,
how does
it may not be, but it might be. It might be if there had been a disclosure in appendices and the lawyer had been allowed to see them. The lawyer might have given advice, and the husband may or may not have reflected. I'm not saying he would, but I think it's very difficult simply to blanket say wouldn't have made a blind bit of difference.
Well, it is a question of...
It may well not have done. I'm not saying it would have done.
Well, the judge found, as a fact, that it wouldn't have done, that he didn't think it was material. That's the judge's finding, and this court is going to have to decide that's wrong. That
well, if you decide that he was wrong in saying it wasn't material, non-disclosure.
Yes, I think material non-disclosure, of course, has a very specific meaning in insurance law. Whether or not it's material is, of course, peculiarly fact-sensitive and was at the heart of what the Supreme Court said in Radmacher, which I'm now going to take.
Thank you.
Just keep an eye on this. I mean, got to be careful how you use the word material.
Yeah.
I mean, if you make a statement, I have made full disclosure to you, and you have left out a substantial part, one might say, well, just that is it's a material part. It's a material non-disclosure. It's not a de minimis non-disclosure. If you do so deliberately, generally, does it lie in your mouth to say, but it wouldn't have made any difference? If I make a deliberate non-disclosure, can I avoid the consequences of that by saying, yeah, but the person who they wouldn't have paid any attention anyway? It's not normally the way the law works, is it?
I think in terms of a contract, of course, that all depends on the particular facts of any particular case. Your lordship may well be right, but on the other hand, the odd thing is that these PNAs, they aren't actually contracts. They aren't.
No, I believe me, I fully get that I'm not sitting here with, but I am trying to bring some sort of legal thought process to this.
Absolutely, and we are all, as it were, learning about prenuptial agreements and how they fit into the overall architecture of the law. But can I take the court to Radmacher?
Certainly.
Which is at Appeal Authorities Bundle 1, and it's at page 17. It was, of course, 15 years ago. And my learned friend has pointed out that in this case there were two children. They were both quite rich, in fact, originally, but the husband gave up his job, became disenchanted with banking, and decided to study full-time at Oxford for a doctorate. The judge held originally that some weight should be given to the antenuptial agreement, but its preparation had been very one-sided. And the husband had received no independent legal advice. There had been no disclosure of assets, and two children had been born to the marriage, as well as making awards he could provide for the children. The judge awarded him £2.5 million to buy a home. On appeal to the Court of Appeal, they held that in the circumstances of the case, the judge should have been given the antenuptial agreement decisive weight, and should have made provision only for the husband's royal part, and not otherwise. The conclusion was not a lump sum to buy a house, full stop, but long-term, the cost of home in London would not be the husband's absolutely, but revert to the wife after the younger child's 22nd birthday, and the income fund be reduced to provide only the appropriate income until that date. On that basis. To the Supreme Court, the conclusion came, and this is important because it refers specifically in the holding, correctly in our submission, to public policy. The idea that it's contrary to public policy is now regarded as obsolete, and the court should give weight to an agreement made between the couple prior to and in contemplation of their marriage, as to the manner in which their financial affairs should be regulated in the event of their separation in circumstances where it would be fair to do so, even if the result would be different from that which the court would otherwise have ordered. On the application of ancillary leave, the same principles in relation to antenuptial agreements as applied to postnuptial agreements would apply. And then 4, dismissing the appeal, the Court of Appeal had been correct to conclude that the needs of the husband were not a factor which rendered it unfair to hold him to the terms of the antenuptial agreement, subject to the wife being required to make that provision for the needs of the children and the family while resident with him. I anticipate that certainly at least 2 members, if not 3, if I may respectfully say so, are very familiar with this case, but perhaps I may briefly highlight 1 or 2 points.
Certainly.
If we go to page 45, this is what I'd order Justice Snowden described as the run-up to the passage which my learned friend relied And it is interesting that the material lack of disclosure, the italicisation of the word material, shows that in the view of the Supreme Court, the materiality of the lack of disclosure and information or advice was important, and says sound legal advice is obviously desirable. This will ensure that a party understands the implication, and full disclosure may be necessary to ensure that it's clear that if a party is fully aware of the implications of the antinuptial agreement and indifferent to detailed particulars of the other party's assets, there is no need to accord the agreement reduced weight. Well, that passage, in a sense, summarises the submissions I've been endeavouring to make here. That notwithstanding the undesirability of an incomplete appendix, and notwithstanding the letter written invoking Dubai jurisdiction, the essence of it, of our case, and indeed as the judge found, is anchored in paragraph 69, where there had in fact been no disclosure or no material lack of disclosure, and the party was indifferent to detailed particulars of the other party's assets. It is not suggested, there is no case here that husband would not have married or would have come to a different agreement if he'd known there was more. It would be an unattractive submission, and it's not one that I understand the learned friend makes.
But indifferent to detailed particulars of the other party's assets, as I understood it, in essence described the position in Radmacher, didn't it?
Yes, but we extrapolate from that to this case.
Do you say husband in this case was when signing the agreement indifferent to detailed particulars of the other party's assets?
Yes, because if one looks at the tone of the advice, the tenant's note, it's quite clear that this was a drop hands agreement. If it's a drop hands agreement, you take out what you took in. What a wife has, as it were, before marriage, which is the assets, what she acquires in her own name, which is not a joint asset, that doesn't come within what the parties wanted to agree.
The reference to material is material lack of disclosure.
Yes.
And there's a distinction in paragraph 72, because they there talk about, or he there talks about, misrepresentation. So when Lord Phillips observes that the Court of Appeal were right in principle to ask whether there was any material lack of disclosure, information or advice, what's he mean in that context about distinguish between a lack of disclosure which is material and isn't material?
Because there was no disclosure at all.
I understand that. So I mean, you couldn't have a material
Yes.
because there wasn't any. So it wasn't material in that case. But looking at it more generally,
I think material.
I mean, does it mean material in the sense of insignificant?
Yes, it doesn't. Does it make any difference? In other words, was it?
But does it make any difference to the disclosure? Do you see, rather than does it make any difference overall? Is it just saying you can have a material lack of disclosure or an immaterial lack of disclosure? And I'm emphasising the word disclosure because not that it's material in any broader sense other than confining it to
Well, actually,
the extent of the disclosure.
He does say whether any material lack of disclosure, comma, information or advice.
I understand,
So
yeah.
the materiality does in fact cover all those 3 points. So the essence of material is not, as it were, peculiarly attached to
No, I understand that, but the same might apply in respect of material lack of advice.
Yeah.
That you get advice, but it's it's incoherent or something like that. So you've had a material lack of advice because the advice is incoherent. Rather than stepping back and looking at the whole process overall and saying it's got to be material in the sense of, and I think this is what you were hinting at, wouldn't have made any difference. And I'm not sure that that's what is being said in paragraph 69.
We would submit that properly analysed it is what is said, because if we get to the sentence which we highlighted read, but if it is clear that a party is fully aware of the implications of an anti-nuptial agreement, pausing there, the implications being drop hands, and indifferent to detailed particulars of the other party's assets, there is no need to accord the agreement reduced weight because he or she is unaware of those particulars. So I think that has to be read in the light of that sentence.
Right.
So you
what-
say that because in our instant case, husband knew this was a drop. He knew A, his wife was wealthy. B, this was a drop hands prenup. That's it. Doesn't matter what the agreement says. Doesn't matter how deliberate or otherwise the misstatements in the agreement were.
It may be regrettable, but it doesn't actually go to the root of it.
So that shouldn't in any way. So that,
Because all these matters were before the judge, of course. There's nothing new. All these arguments were very compelling.
no, but I'm thinking in a more broad term that you're saying that if you have a drop hands prenup and one party knows that there's a disparity of assets and they might come out of the marriage with anything more than they took in, doesn't matter what an agreement says, and people can make deliberate non-disclosures and misstatements in the agreement with impunity.
No,
I'm putting to you. Sorry, I should have rephrased it. I mean, is that not though the consequence that one should take from your submission?
No, because one will look with respect at the facts of a particular case, and there may be cases where one simply can't hide behind failing to disclose because both parties have entered into an agreement on a completely false premise. But here, on the facts of this case, as the judge found them, here was a man who was entering into a marriage. He was an intelligent, well-educated man. He knew that his wife was much richer. He had taken legal advice. He wanted a drop hand settlement. So on these facts, we submit that he's plainly within what is
But he had took some legal advice, but he was told basically he couldn't have the remainder of the legal advice if he wanted proper disclosure. He was told you get one or the other.
Well, with respect, I mean, we can't have as part of the law an analysis of the quality of the legal advice, because of course in Radmacher it may not be necessary to take legal advice at all, as is the case in some of the cases I described. The question is, broadly speaking, was he prepared to enter this agreement, notwithstanding the fact that there might be other assets? Because really it didn't
No,
matter.
notwithstanding that he was told by her that if he wanted legal advice, he couldn't have disclosure.
In a sense, he did have legal advice, and
Preliminary legal advice.
we can see that he did have legal advice, and that he decided to go. Whether he was wise to do so, of course, is another matter. But was it material? I'll come back to that point at the risk of repeating myself. We submit that it was not material, notwithstanding as we absolutely accept, it's desirable in most cases, unless there is an explicit. I mean, there is reference to waiver, of course, in the agreement itself.
Thank you. Are there any other parts of Radmacher you want to take us to?
There is a slightly confusing aspect of paragraph 75. I think our Lord Justice Moylan referred, I think, to what McLeod said before to that. And then there was a quotation there, which is at the bottom, and then at the top of the page. It's slightly unclear, although we're still researching the matter, whether that is in fact a quotation.
Oh, I see what you mean. Yes, it says in preference to that.
Well, exactly. So that but in this case, it's
right.
rather odd that it should be put in inverted commas.
Yes.
Yeah.
When I read this before the case, I was generally confused. Came to the conclusion, possibly wrongly, that this was in fact Lord Phillips. or
Crafting something, yeah.
in saying, this is the way I prefer to put it.
Yes. Yes, you're right.
So that's our submission as to what he's saying.
No, right.
Yes.
In which case the judge in our case was right and I was wrong with it.
I'm afraid that is the reluctant conclusion.
No, so I'm just reverting to my normal operating procedure. That's right.
Just going down the page, of course, autonomy, very important here. 78, the reason why the court should give weight to nuptial agreements is there should be respect for individuals. It would be paternalistic and patronising to override their agreement simply on the basis the court knows best. That, of course, is fundamentally true. And then we've also highlighted the non-matrimonial property section there. can I come to needs, which is at page 48, paragraph 81. This is the section about the predicament of real need. Of the three strands identified in White and White and McFarlane, it is the first two, needs and compensation, which most readily render it unfair to hold the parties to an anti-natural agreement. I state that because the concept of needs is seen in the light of analysing whether or not there should be an anti-natural agreement which is honoured by the court. The parties are unlikely to have intended that it should result in the event of a marriage breaking up and one party being left in a predicament of real need, while the other enjoys a sufficiency or more, and such a result is likely to render it unfair to hold the parties to the agreement. Equally, if the devotion of one party to look after family and home has left the other free to accumulate wealth, it's likely to be unfair to hold the parties to agreement that latter retains all that she has earned. Where, however, these considerations do not apply, and each is in a position to meet his or her needs, fairness may well not require a departure from their agreement as to the regulation of their financial affairs in the circumstances of the counterparts. Thus, in relation to the third strand, sharing, the court would most likely to make an order in place that would otherwise have made. And the predicament of need question was considered, as I indicated in my opening remark by Mr. Justice Foster, but then qualified very considerably by him in his book, Shelf Analogy. The question, I think, to come back to a question that I was asked by my Lord, Lord Justice Snowden, which is there a difference between looking at needs if you were to decide that the judge was wrong in relation to giving respect to the prenuptial agreement? There might be, but as I said, I think in answer to that question, one looks at the way he approached it. He did actually approach it in a pretty general way, and it's not obvious, I would submit, that he would have come to any different conclusion had these simply been a young couple after a short marriage, both brought something to the marriage. In fact, in those circumstances, I'll come to that, what we say about needs more generally. But there are two ways we submit that needs can apply in these cases. If obviously the needs are not catered for at all, then it may be the court will decide that this is not an agreement that should be honoured. But we say in this case, for example, you can't contract out of your obligation to children effectively. And indeed, clause 29 of the agreement especially envisages things will be different with children. In any event, you can't do. And the court in Radmacher, of course, decided that there would be a special arrangement for the husband, notwithstanding the agreement that to a limited extent he would be entitled to property to house the children until they were 22. The page 55, paragraph 14, the Court of Appeal differed from the finding of the judge that the anti-nuptial agreement was tainted by the circumstances in which it was made. Wilson held that he had well understood the effect of the agreement and had the opportunity to take legal advice, but failed to do so. In these circumstances, he could not play an aid the fact that he had not taken legal advice. The judge held the wife had failed to disclose the approximate value of her assets. Wilson J. observed the husband knew that the wife had substantial wealth and had shown no interest in ascertaining its approximate extent. More significantly, it made a suggestion that this would have made any difference, any effect on his readiness to enter the agreement. This, of course, is echoing the submission I made in this case. And paragraph 17, we agree with the Court of Appeal that the judge was wrong to find the anti-nuptial agreement had been tainted. We also agree that it is not apparent the judge had made any significant reduction in her award to reflect the fact of the agreement. So she should have made a deduction. This is the judge at first instance. And then paragraph 119, we stated at paragraph 73 about the question of fairness can often be subsumed to the question of whether it operated unfairly in circumstances prevailing at the breakdown of the marriage, and this is such a case. Had the husband been incapacitated in the course of the marriage, that he was incapable of earning his living, this might well have justified, in the interests of fairness, not holding him to the full rigours of the anti-nuptial agreement. That's also something reflected in section 29 of the agreement. Clause 29 of this agreement. This was far from the case. You had to fulfil generous relief given to cater for two needs would directly provide for the needs of the husband. In these circumstances, so the court was correct to conclude that the needs of the husband were not a factor that rendered it unfair. We go to page 58, paragraph 30, under the heading "The Court of Appeal exercise of discretion." I agree with the majority that there is no reason to set aside the Court of Appeal's re-exercise of the statutory discretion undertaken after concluding that Baron J erred in principle. She held the husband to be entitled to a house of his own. The Court of Appeal limited that, and essentially what the Supreme Court was saying was the Court of Appeal came to the view they did, viewing the position overall, did not seem to be justified in concluding husband has or is likely after that period having means generated as a result of parenthood, which would not be covered by the Court of Appeal's order of his own resources. So our submission is that essentially that this court will not readily interfere with an assessment of needs unless it can be shown to be a misdirection of law or outside the bracket of what judges might reasonably conclude in these cases. There is one passage in Lord Mance's judgment at 130, which we've also marked, where it also deals with the question of discretion and the generous assessment and needs generated. I don't think I need to read that out. So the judge referred explicitly in his case, this is in our case, only to Granatino. But of course, as my learned friend said, in the skeletons before trial, both parties had referred him to a number of different cases, and including Ibeki, Cummings and Fawn, and indeed the Court of Appeal's decision in Brack, which a decision which my lady gave the leading judgment, and the decision MN and AN, and all those cases were no doubt in his mind, although we would respectfully submit, notwithstanding, for example, the helpful analysis by Mr. Justice Peel of the principles, sometimes safer to stick to what the Supreme Court said in terms of extracting the principle which can be applied to those particular facts. Because if one looks at all those particular cases, and they're all in the authorities, they've all got different facts. Very often they're children concerned. There's nothing very close to this case on the facts, and so I'm not sure that one gets a tremendous amount by looking at all those cases. We do, however, get something we submit from looking at the approach of an appellate court generally to decisions of this sort. Can I take the court to Appeal Bundle 1, the case of Piglowska and Piglavsky, which is Appeal Bundles 1, page 3, and the well-known speech of Lord Hoffman, which we can see. Yep. At page, the Court Report 643, 14 of the authorities bundle. He also quotes himself in Biogen, and he makes, by referring to a well-known case in G&G, it is not, of course, not enough for the wife to establish this court might or would have made a different order. We are concerned with the judicial discretion. And so the essence of such a discretion, on the same evidence, two different minds might reach widely different decisions without either being appealable. It's only where the decision exceeds the generous ambit within which reasonable disagreement is possible and is in fact plainly wrong that an appellate body is entitled to interfere. And then he gives a good further elaboration further down the page and over the page, which I'm not going to take at court two, although it is helpful. And then at page 97 of this bundle, there's the case of Reed B, which is a hair order case. But at page 119 of the bundle, there is a useful summary by Lord Newburger of the approach to interfering with findings of primary fact. And we have highlighted there the passage which we say is particularly helpful. And then finally on this case, there is a case called Fage and Chobani, which is at page 195 of this bundle.
I'm surprised that you haven't, that between you didn't decide to put Volpe in, which obviously is after page.
Yes.
It has the glorious paragraph 2.
I remember it well, and your ladyship's quite right to remind me of their omission. I'm sure it will, but it won't mine. Of course, the Phage case about Greek yoghurt, quite a long way away from these facts, but nonetheless, it's page 195, appeals on the fact. The appellate courts have been repeatedly warned. It then deals with the well-known concept of island hopping, and that's at paragraph 14, subparagraph 4. What the learned friend has done very skillfully, of course, is effectively try and re-argue the facts before your ladyship and my lords by extracting particular letters, by looking at drawing your attention to particular parts of the transcript, which is very much island hopping, we respectfully submit. It is most important to bear in mind the advantage the judge had by looking at the evidence overall and assessing the witness. And it's interesting that at paragraph 116, what this is the 6th line down, the judge heard evidence over 7 days and read a mass of material. I would therefore be most reluctant to disturb any of his findings of fact, whether primary or evaluative, unless compelled to do so. And of course, that is, evaluation includes particularly describing questions of credit throughout the transcript, and perhaps even in some of the passages that you've been referred to. The judge is directing himself according to whether or not a particular witness is honest and whether he assesses their credit or not. He comes to some very, very clear conclusions about that. I don't need to spell them out. I don't want to
We have those.
but I'm sure the court has it well in mind. Now that makes it particularly inappropriate, we respectfully submit, for this court to go against the findings that he made. Simply also, in relation to what the husband's attitude towards the prenuptial agreement was, these are findings of fact, notwithstanding the fact that points have been perfectly fairly to put to me about what's in the agreement itself. The question is, what did the parties really understand? And that's something that can be obtained really only by extensive oral evidence, which the judge was able to assess and came to a firm conclusion. So it is a very high hurdle, we submit, for the court to, for the appellant to mount in order to disturb that finding. Our submission was below on the question of needs, and perhaps I can give the court reference through the passage of time rather than
Certainly.
About. We made submissions at page 167 of the supplemental bundle. That's the opening submissions, and then closing submissions.
So that was your opening to 167.
I think I probably have got time to deal with this. All these submissions, of course, were before the judge, and if we go to page 168, we can start at the bottom of 167, where he is dealing with the husband's assertion that the prenuptial agreement does not produce a fair outcome having regard to his needs. He signed the prenuptial agreement, deals with fairness, disclosed his assets, including joint assets. There's H suggestion that he should be compensated for his decision to pursue a career untenable. His case is he sacrificed a career to work in the family business, but not least because he signed the prenuptial agreement after he had stopped working for father's business. And this has echoes of Radmacher. Then no children, we deal with at 79. The needs approach pursuant to section 25, paragraph 80. The source of wealth is relevant to needs. And there's a footnote we deal with there. And we also make the point that upholding the prenuptial agreement will not leave him in a predicament of real need. He owns a house and has additional capital for which he can fund his alcohol treatment and fund his income needs whilst he addresses his mental. And he has health issues, he has a significant earning as a chartered accountant. Housing, he's not without a home, as recorded in Salford. If he wished to upgrade his accommodation, get further capital, he has rental income, although he says it's de minimis. There's no need for him to own a property, and the word needs, of course, is there. The properties he submits are wholly unreasonable, and this really is something you repeat in all submissions. He's chosen the most expensive type of apartment, a serviced apartment. I think it's a 3-bedroom apartment, something which the parties never had during their marriage, in among the most expensive neighbourhoods in Dubai. He also has a share in the Marbella property. Then we deal with income needs and earning capacity, and then there is a chart there on the next page dealing with dividend income from the shareholding in the family, and the question of his budget, which we submitted, was absurdly inflated. I don't think I need to take you to it, but the closing submissions are at page 200, and the relevant paragraphs 42 and 43. And then the skeleton before your lordships, your ladyship, is at the core bundle, page 72, which is where we deal with needs, which is grounds 3 to 8, the assessment of H's needs. An elastic concept, I don't think that will be...
What paragraph?
I'm sorry, it's paragraph 70.
Thank you.
It's page 72 and paragraph 70.
Thank you.
Sorry, I'm going quickly, but
No,
I'm
not at
conscious
all.
of time.
No, we're doing...
Needs are an elastic concept which cannot be considered in isolation, and then we make the same points in relation to the prenup, lack of marital request, length, and there's no need for generosity in the assessment of H's needs. Although, in fact, the judge said he was being generous, of course. We then deal with the marriage lasting for 3 years, cohabitation for an initial 2 years. But we do make the submission there that in a case involving a prenup, premarital cohabitation predating signing is slightly less relevant than it might otherwise be. Given the finding that, and this was the finding, that the husband had freely entered into a drop hands PNA by which he intended to be bound, it was open to the judge to exercise his discretion as to award nothing. Now that may seem a bold submission, but it isn't really, because if you have a drop hands means precisely that. And if the judge, as he did, found that the agreement was an effective one, then apart from an accounting adjustment to deal with their joint investment account, there was actually no need for the judge to go further and award him anything at all. So that's why he was being particularly generous. So we then say, nonetheless, the judge exercised his discretion generously and made a capital award. We make the point, I think, which I think is probably uncontentious, that you can't rely upon your own unreasonable litigation conduct, which depletes your resources to, as it were, ask for more. He's criticised the judge for not setting out the whole of Section 25 of the Matrimonial Causes Act. That can't be a fair submission. He clearly would have known what the provisions were. We've included in the bundle, of course. He had already finished his employment with the wife's father by the time he'd signed the prenuptial agreement. And the evidence in relation to his decision to leave PwC was in the event disputed. And the wife's evidence was the decision was driven by him. And he told the wife he's not working, he would go back into one of the big 4 accountancy firms.
No, but there was no finding by the judge.
There was no finding as such, but it's an issue anyway. There's no finding either way.
No, quite.
And he hadn't been a great success. That was the case in terms of working for his father, and there's reference to WhatsApp messages. There is also, we make submissions about the venture into online trading, and he says that the sums were spent on the understanding this was to their family home, which is simply not borne out by the facts, because in June 2021, the wife's father transferred into his sole name the property, and he gave inconsistent oral evidence, and the judge found that he wasn't being honest about that. that he'd be entitled to half of the value if the marriage ended, is of course not consistent with the agreement, but the judge made a finding about his oral evidence as well to bolster up that. There's also a slightly peculiar idea that the mental health issues were caused by the separation. There were other factors, I think I can just leave it at that, which are well and truly recited in the medical report. So the judge made assessment of the capital needs, and we know what he did, erring on the side of generosity. He was specifically directed himself into, by relation to Section 25. He didn't say that he was going to reduce it because of the existence of a PNA. He simply went through a process of deciding what he thought was a fair reflection of the needs, and came to a conclusion that he would not quibble, for example, about the money for a car. He was generous about a number of aspects. He didn't take into account, for example, the half share of the party's joint savings. He wasn't required to sell his property in Salford. There was also reference here to what happened about transferring money and to dividends. These are all details which the judge had well in mind, and with great respect, despite the invitation by a friend asking the court, as it were, to go through this exercise itself, most unsatisfactory to do that, unless the judge was obviously wrong in doing what he did. And we submit that he was not obviously wrong. In fact, we were disappointed by the result, because on one face of it, having decided there was a binding agreement or effective agreement, why did he need to order him to pay anything at all? In fact, he was generous. And we submit that there is no basis on which he could reasonably be criticised, certainly not the basis of an appeal. The wife produced estate agent evidence. We refer to this at paragraph 88, that actually a two-bedroom apartment could be bought for 440 to 540 in the same block where they previously lived. And the judge did not think a capital sum was appropriate, but as the court is aware, a limited period in which he could get back on his feet again, given the difficulties. Also gave him a generous award for income. We respectfully submit this case on need is an extremely weak one. It's simply based on the fact that were he to be have been a woman and married a rich man, then he would have got more. The judge said he did not regard himself as being discriminating. It's not to do with gender, it's to do with the level of sophistication that they had when they reached this agreement. And that agreement was one which, in our submission, consistent with the public policy identified by the Supreme Court in Brandisino, this court ought to honour. Lords, they were married in the summer.
Sorry, you were talking. Do you mind if I ask the question now? I'm not sure. I interrupted you.
No.
Do you want to finish what you were going to say?
No, I'm very happy to be interrupted. Well, reasonably happy.
You don't know the question yet.
You don't, yeah.
No, that's
It's because you were going through the what the judge has done and erring on the side of generosity, and the impact on his assessment, the issue of the impact on his assessment of needs of his having upheld the prenuptial agreement. I want to ask you a question about paragraph 145 of the judge's judgment.
Yes.
And it's the last two sentences of that paragraph in particular. He's here dealing with housing.
Yes.
He starts the huge issue here for me to determine is whether the husband should have to rent or a property purchase for him. And then at the end, he says, I'm going to delete altogether the cost of purchasing a house. I found that that is the wrong thing to do, having regard to the terms of the prenuptial agreement, which I'm applying, albeit varying marginally to meet short-term needs. And that, just reading that, that's the same approach that was applied in Radmacher. Just reading that, it might suggest that his assessment of needs, in particular in respect of housing, was influenced by his upholding of the prenuptial agreement.
Your Lordship has identified the only passage in which I think you could arguably said that it was. My
Sorry.
answer to that point is this, that and this raises a genuinely quite interesting point, which is that if you reach an agreement, as these parties did, the case for the wife is that the lack of disclosure was such that the court ought not to inform it. Does the court simply ignore everything which was in the agreement, as it were, just to put it aside and say nothing? We submit that, of course, the judge did find that it was effective, but what is clear from the agreement is, notwithstanding the unsatisfactory nature of the disclosure, was that both parties wanted to move on theoretically and to have a drop-hand settlement. So the court is entitled, the judge was entitled to bear that in mind, but it's not clear when one actually looks at what he does, that although there is that particular passage, if there is any reflection in his calculation as to why he did it. For example, he doesn't say, I'm going to reduce it by 30% having regard to, or I'm going to
No,
lock
but he
off
says
this
pretty
or that.
clearly, you're not getting a house because I'm upholding the prenup.
Yes, but does I ask rhetorically, does the fact that there is not a rhetorical mean that he is automatically entitled to a house?
No, no,
And
no.
there one stands back and looks at the fact
Understood.
that this is a short marriage. Both parties were anxious to leave it, as it were, with what they came in, and therefore that's a reasonable approach, not whatever frailties there might be in the prenuptial agreement. And of course, the court has my submissions about the prenuptial agreement, which is that you shouldn't interfere with what the judge concluded. But even if you were to find there were some unsatisfactory elements of the disclosure, it doesn't, in my submission, mean that you should ignore all the surrounding facts, all the evidence the judge had as to what was fair, and all the evidence leading up to the signing and concluding of the prenuptial agreement. And that's a factor that he could take into account. He doesn't, as it were, assume there was no attempt to try and agree these matters. But even if he was, we submit that standing back, this is well within the bounds of a discretion, even if there had been no prenuptial agreement at all.
Ms. Bangay's submission was that I mean, I appreciate it's very far down the line, but if we get there, that we shouldn't remit the case for rehearing, that we should ourselves conduct any required fresh needs assessment. What's your submission in response to that?
Well, of course, time has been such that I haven't been able to develop in detail all the arguments about the relative properties. I've tried to refer you to what we say in writing, and I hope I can assume that the court will have that available, and indeed the rival properties.
Well, then you put in the respondent's notice. So
We put in respondent's
Yes.
notice as to give further reasons. A rider, in fact, we put.
Yes.
We deliberately did not, in fact, appeal, notwithstanding the fact that I have indicated that there were potentially grounds for a cross appeal on the basis that the judge was far too generous. And that is actually characteristic of the approach of my client to this litigation.
for getting to the question, I mean, we've got your submissions. So remit or
My instinct is one thing, but can I take
Yes.
instructions?
Of course. Instructions.
I have, my lady, and although it's not, as it were, a perfect scenario, we do think that it's desirable this matter should end here. At least there should be no further hearing, subject, of course, to appeals on points of principle. But as far as the question of assessment of needs is concerned, I hope that the court, if it finds it necessary to revisit the issue, has enough material in our various submissions. Can I just take the court to the supplemental bundle 207. Where this is a letter written by solicitors for the husband to those instructing me on the 23rd of August 2023, and it deals in detail with the proposal which is made, including a housing of 1.75 million.
Yes.
And deals with the question of rent, the car, Dubai residence and moving costs, and comes up to a total lump sum of 2,533,000. And there seemed to be a suggestion in the course of the learned friend's submission that the approach of those instructing me was unreasonable. May I actually refer to what those instructing me said in September 2023, which we can find at page 222. This helpfully sums up the genuine attempt to try and come up with a satisfactory compromise to this case, a lump sum which was considerably in excess of what, in fact, the judge found was reasonable. May I refer to particular to 224, where those instructing me make specific reference to advice given by the courts as to how to approach these things. So time does not permit me to go in, but it would be unfortunate if this court was left with the impression that there wasn't a genuine attempt to compromise this case on behalf of my client, who wanted to finish the whole matter, and made an offer which was more generous than she need to have done. And that's a matter which the judge himself recorded. She married in summer 2019, is my final paragraph. They separated in mid-22. I take that as halfway point because there's a contention as to when they did actually separate. She applied for divorce in September 2022, despite a prenuptial agreement. Here we are in March 2025. So it's taken as long to conclude this dispute as the time they were actually married, not to mention the question of considerable expense to both parties and use of court time. And I ask correctly, does this reflect the public policy identified by the Supreme Court in Granite Law? They decided that as public policy, in appropriate circumstances, that should be given weight in allowing these agreements to be reached, an agreement to drop hands by two mature people. We respectfully submit for this appeal to succeed, that policy would be ignored. And in a case where the judge has made clear findings of fact after a fully contested trial. Those are my solutions.
Sorry, can I just be very clear? What particular findings of fact in that last respect, i.e. as to what husband knew about the materiality or what he knew about the disclosure, are you relying upon? Can you be very specific?
I'd rather not be tied down to one matter because it's all set out in our skeleton argument what we rely on. But
you give the reference to skeleton.
Yes.
I've certainly got the skeleton.
our skeleton begins at page 54 of core bundle, and we deal with
disclosure from 11
material
onwards.
non-disclosure at page 58, and
Which findings of fact? You
yes,
say that we
if
can't-
you look, I'm endeavouring to assist the Lordship. If you go to paragraph 15, page 59. We thereafter go into considerable detail about what the judge found, in concluding, and this goes over several pages, paragraph 30, in the light of the judge's finding, husband cannot credibly say he would have declined to enter into the DNA. Additionally, refer to these business interests specifically, etc. We refer to what he said in the judgment, paragraph 64, at page 102, various findings there, paragraph 64 and 102 in particular.
I've lost you, sorry.
Well, there is a great deal of material here, starting at paragraph 11, and then going on to, well, really the whole of our submissions are to deal with the extent to which the judge found. We make frequent references to the judgment and various paragraphs in it.
Okay, because the reason I was asking is that I think as I wrote down your submission earlier, and it's paraphrased, not verbatim, but you said it was a very high hurdle that the court would have to surmount, if you like, to disturb the findings that the judge made about what the husband thought about, and then these are my words, the materiality of the disclosure that he'd received. Did I get that wrong?
The question is, was the materiality is crucial, of course, but did the husband, was there any reason that the husband's consent was vitiated by reason of the fact that there was a greater amount of money, in fact, than was disclosed on the appendices? And the judge obviously had to consider that argument. It was central to the case below, and he did not come to that conclusion.
Okay, because I'm just trying to find the judgment.
He deals at paragraph 64 with his view about the relationship between the wife and her father. That's one fact.
Bear with me, for some reason I just find that voice operator is just being operator error. Is the core of the findings that you say we can't interfere with or shouldn't interfere with at paragraphs 129 and 130? Or is it somewhere else?
That was dealing with the hands behind the back. You'll always be a Helliwell. I think it would be a little bit dangerous for me to commit myself to particular paragraphs, frankly.
Well, except you're saying that we can't interfere with findings of fact. We shouldn't interfere with the findings of fact. So I'm just asking you to be specific about which findings of fact you say we can't interfere with, which mean that applying the Radmacher approach, the non-disclosure that took place in this case was not material. That's what I'm trying badly. I'm sorry to push you on, because I'm trying to focus on what you say, is critical.
Well, first of all, did it make any difference? And then you have the findings in relation to credibility of the parties here. Quite clear findings.
Yeah, but I understand the findings on credibility in some other respect, but is it materiality? So I thought your submission was the judge has made some findings as to what was material here and the materiality of the non-disclosure, and you can't, Court of Appeal, interfere with them, or you shouldn't. I'm just trying to be clear, and if I'm barking up the wrong tree, I'll be.
I think, with respect, my lord and I have been rather departing on the materiality and using contractual and insurance contract analogies. I'm not quite sure that's the way the judge did it.
I'm using the expression used in Radmacher.
Yeah.
In paragraph
Material to the
69.
decision.
Yeah, materiality that you took us to, paragraph 69.
Well, if we look, for example, at what this is picking up what my learned friend said at page 114, paragraph 101. This seems to me gives the strongest part of the objection launched against the prenuptial agreement ability by the husband. It says, Miss Bangay asserts that when the wife eventually provided, when the amended agreement was sent to her, the wife openly admits she deliberately grossly understated her wealth by excluding her business. This is the point that she made before. My recharacterisation would be the wife did not know the full value. That's what he found.
That's looking at the wife's state
Yes.
of mind or otherwise.
But I agree that the wife did not give full disclosure.
Yeah, and he makes that explicit finding. So what I'm saying, your answer to that is that you accept that there was a finding, there was not full disclosure, but you say that was immaterial in circumstances where the husband knew that he was entering into a drop hands agreement, a prenup, and his wife was more wealthy than he was, or very wealthy, however you put it. And you say that's enough.
Can I go on to paragraph 104? It's clear that the husband was expressly advised by Hall Brown to seek further disclosure, and he declined to do so. This is the judge's finding. The husband says that he was put under unreasonable pressure. I reject this submission. In one sense and circumstances, one party is substantially wealthy than the other. It's probably more often the case than not in prenuptial cases, because why have one if they're either the same amount? Generally, the person with this money would rather not have the prenup. I've thought carefully whether it's unreasonable pressure for a spouse to say, if you do not agree to sign this, I will not marry you. So he was even dealing with that hypothetical point. And he gave reference to Baroness Hale, who was the 1 out of 9 who dissented. But 8 judges, I do not need to spend long looking at other persons' decision. I looked at the decision, and then he goes on to deal with Radmacher. So he was rejecting the husband's version of events, which was that surrounding the prenuptial agreement.
Insofar as he's dealing with, it seems to be 103 and 104. One, he says you can't get out of it simply because someone is much wealthier than you thought. But the second, and I raised this with Miss Bangay, it's his conclusion that the husband was advised to seek further disclosure and he declined to do so. Do you support that? And if so, where
Where's
in the evidence that he declined to do so?
Well,
Seek further disclosure.
yes. It's a matter that's discussed in the advice, which we've seen, the attendance note. And we know that he did not do so. It follows that he declined to do so.
Sorry, he did do so. He asked, he specifically said, if I get disclosure in, I get either, I have a choice. Sorry,
Yes.
he got disclosure to him of Appendix A. On that basis, he decided not to take legal advice.
Your lordship's referring to the email which was sent. Yes. Well, he didn't. In fact, he did what he had. He had autonomy to do what he wanted to do in respect of that. He could have taken a different view, but he didn't take that view.
He did ask for disclosure, albeit to him.
But he didn't have to sign the agreement. He was unsatisfied with it. He could have said, I need further time to take legal advice.
Yeah.
He was given some legal advice. It said you shouldn't sign it, or you might not be able to sign it until you see the appendices. He went ahead and signed it. He's a man capable of making that decision. And the judge had to look at him overall, having seen him cross-examined, and came to the conclusion that it would be fair in those circumstances. not to do so. Of course, you don't have to take legal advice at all, which is one of the factors in some of the other cases. They refer to that. So, with respect, it's be most unfortunate if this court, whatever it decides, were to make it very difficult to enforce a pre-marriage agreement unless there had been legal advice taken at a certain level or there had been complete disclosure. It will depend intimately on the facts, which is why we submit it as a considerable hurdle for a party challenging prenuptial agreement, unless there is one obvious undue pressure, which we submit there was not here.
Thank you. Thank you very much indeed, Mr. Yes.
I'm going to be very brief. But may I just deal with the issue of needs and point out that the award sought by my client amounts to 2.29% of the wife's overall wealth. And secondly, as I understood Lord Folkes to be saying that my client made no contribution to the marriage. Well, my lady, my client made a full contribution, and it's never been suggested to the contrary. And within that contribution, side by side with the wife, after the moving into the what became the family home, he and the wife worked side by side for a period of 2 years, renovating the property. And the pictures, which I invite you to see if you want some colour, are the pre-renovation pictures of 449 to 452.
We've seen them, thank you.
Yeah, and the post-renovation of 453 to 460. As to the assessment of needs, if the prenup is not upheld, then it's a clean sheet. The court isn't constrained at all in the way it assesses needs, save on the conventional basis. And in my submission, bearing in mind the standard of living enjoyed by the parties, the length of the marriage, and my client's full contribution, such needs would be very generously assessed and would include housing going forward. And there can be no room in my submission for discrimination. And it was self-evident that the judge's, the paragraph that my learned friend took you to, where he deals with the question of housing, was unfortunately, in my submission, discriminatory. Mediation. The judge's conclusion that mediation was not suitable, in my submission, is not supportable. We who have practiced in this division for many, many years know that ADR mediation is successful in even the most difficult, complex and angst-ridden cases. It was the wife's decision to include in that prenuptial agreement a mediation clause. It was the wife's decision to ignore that clause, not only ignore it, but to drive a coach and horses through it by reason of what I call the Dubai letters and the stance taken by her solicitors, contrary to that one, the one adopted by the husband. Finally, credibility. As I understood my own transmission, forgive me if I'm wrong about this, but I understood him to be saying that credibility is relevant to a challenge of findings of fact. If I've misunderstood it, no, I have understood it correctly. Well, in my submission, it simply doesn't come into play in the sense of the findings that the husband seeks to challenge, because we have pointed to parties' statements, we've pointed to the oral evidence, and we pointed to where the judge went wrong. So unless I can help you with any other matters, those are my very brief submissions in response.
No, thank you very much, Ms. Bangay. Well, thank you all very much indeed, folks. Those sitting behind you, I don't know if both juniors are pro bono, but thank you very much indeed, those that are acting pro bono. You won't be at all surprised to hear that we intend to reserve our judgments. We will try and get a judgment out reasonably quickly, but I'm not making any promises as to a date, so I don't want either of the husband or wife to sit anxiously next week thinking it's going to land in their solicitor's inbox. It'll be sent out in the normal way in draft. Please remember about the embargo on the top of that appears on the top of the draft judgments now. Only for typographical or minor implicities, not to re-argue, please. And we'd hope that you'll be able to agree an order following our judgments. We'll deal with any other arguments on paper.
Thank you.
So thank you all. Again, it's been a long day and
Court, rise if